Okay, great. I think we're going to get started. Thanks everyone for joining and subscribing to the webinar. We're going to try and keep this one as short and punchy as possible. We would like it to be as interactive as possible. So whilst you're in listen-only mode, you do have the ability to text messages through to us. We do have a lot of our current investors online, so if they've got very specific questions related to these new regs, they can start typing. I'm going to attempt to be a moderator during this process, and we'll pose those questions as we go through the slide presentation. But firstly, perhaps what we should do is just introduce everybody. For those of you who don't know me, my name is Stuart Ferguson. I'm the CEO of American Dream. It's a brand that we started in 2007 with a specific focus on investing into the US for EB-5 purposes. We do have a sister company known as 12 Star Capital, which focuses on some of the other alternative residency and citizenship programs. But to a large degree, our core focus has been EB-5. We work alongside immigration attorneys. And at this point, I'd like to introduce Leon Versveld. He's one of our panel immigration attorneys. We've done a lot of business over the years. And Leon resonates very well with South Africans, with him being an ex-South African. So welcome, Leon. Really appreciate you being online.
Dankie Stuart, goeienaand aan almal van julle. My Afrikaans is maar nog 'n bietjie ek weet nie, is 'n bietjie roes. So ek sal maar hierdie in Engels hou. So my name is Leon Versveld. I graduated at the University of Pretoria and have been in the United States for over 22 years. And our practice exclusively focuses on immigration. More specifically, my practice, our firm does a variety of immigration to the United States. But specifically, my practice also focuses on EB-5, which is a highly specialized area within the immigration bar. Today's seminar that we're going to talk about is just something that has recently come to pass, and this is the new EB-5 legislation. So I wanted, before we get started, maybe just for those who are not familiar with the EB-5 immigration benefits, give you a little bit of background of what it is. Back in the 90s, Congress enacted a legislation wherein an immigration benefit, meaning a green card, would be granted to investors who would invest a certain amount of money in the United States, and wherein that money would create 10 specific jobs. And in return, that investor and his immediate family, spouse, and kids under 21 would be able to gain an immigration benefit in the form of a conditional green card. This program has been in existence for quite some time. It didn't really have much traction until 2007, when we had our big housing bubble that burst here, and people were finding difficulty to get money from the typical lending institutions in the United States. It's created a big boom since 2007, and we compete with other similar projects or programs worldwide in Europe, Australia, and the United Kingdom that also provide similar benefits than what this program does provide. So historically, and from its inception, the initial investment has always been tiered into two different type of investments. The one is where you directly invest, and you alone are responsible then for creating the 10 jobs. And that investment was set at $1 million. It was not a very popular investment to make for a variety of reasons, and also because of the high risk that was involved with it. And so for the majority of EB-5 investors who were interested in pursuing this avenue, they were more interested in doing something at the regional center stage, which is the $500,000 investment. So for quite some time, the minimum investment was set at $500,000 if you invest in a regional center. And this is, or $1 million if you invest by yourself anywhere in the country. The regional center was just a designated area wherein immigration would pre-approve a specific project and program in the United States when they need to meet certain criteria. So if you have a project that meets these criteria, they would be designated as a regional center. And then from there, they could then talk to foreign investors to invest into their project, because they would have already provided the facts that their investment would create the jobs that is required, number one, and number two, that their project is also located in what is called a TEA, a targeted employment area. So for the majority of investors, this seemed to be a much easier and much more safer investment to make, because there was not real much involvement on the investor side, and it was really more kind of a turnkey scenario. For the most part, these were historically the most filings that we have received under EB-5 category, and this is also what this seminar is about. Stuart and his team has a variety of projects that has already been pre-approved, and he and his team will talk a little bit later about what those projects are that's been pre-approved by immigration, as far as potential investors who want to invest there and obviously ultimately get permanent residency. So that's a little bit of a background. For the longest time, even since 2017, Congress has wanted to change the legislation because they found there was a few issues with the legislation that was set. Number one, for the most part, they thought that $500,000 was a little bit too low, considering what the global market was and the competitors was yielding. Number one, and number two, there wasn't enough protection for the investors. So there was some projects that failed. There was a big ski resort that failed, and so Congress wanted to make sure that they revisit this legislation and see what they can do to increase, any kind of benefits to the investor, number one, and number two, also gets to get a little bit competitive. There was a lot of back and forth going on, and at some point when the Trump administration came in, they did through rulemaking and went ahead and changed some of the EB-5 regulation, wherein it bumped there for a minute from $500,000 all the way to $900,000 in this particular EB-5 regional center program. During that time, there wasn't a lot of filings. The $900,000 mark seemed to have been a little bit too much for the foreign investor to invest and have his money tied up during this pendency of time. And what happened was there was a lawsuit that was filed by one of the regional centers that basically argued that the Trump administration's then Secretary of Homeland Security, or acting Secretary of Homeland Security, was not he was not appointed correctly. So through a technicality, that regulations then actually went by the wayside, and for a short minute in June, end of June, the regulations went back to what it was before, and there was some folks who were able to file under the $500,000 mark again. It was also right at that time that Congress then came to vote on actually, in most part, what the Trump administration has already outlined as far as making it law. And Congress failed to actually pass reauthorization of the EB-5 at the end of June, which then amounted to a lapse in the EB-5 program. So until such time that Congress would get back to it again and vote. At that point in time, Congress decided to attach the EB-5 again to the spending bill. And then as soon as the spending bill would pass, they would at that point in time have a packet on EB-5 available to discuss on how the EB-5 legislation would move forward. That spending bill kind of had its ups and downs. If you follow the news over on that side, there was some very great aspirations of spending us into a debt that I think my kids would probably still dig out to till today. But ultimately, they ultimately were able to reach a resolution here in March. And we have, with a new spending bill, a new EB-5 legislation. And so, Stuart, if you were to go to the next slide.
So this, Leon, I think that's a great intro and backdrop in terms of where we come from in respect of EB-5. But I'd just like an opportunity to introduce Chris Immelman from Pam Golding. Pam Golding are our strategic partners, and Chris and myself collectively over the years have worked closely on EB-5. And to date, we've collectively done in excess of 300 EB-5 filings. So Chris, it's great to have you on board. Really appreciate you,
Thank you
coming online, and I'm sure you're delighted with this long-term reauthorization for us collectively.
Indeed, we are, Stuart. I mean, we've been waiting for this for a while. I mean, we've been, taking getting our news from you guys, from Leon and the rest of the boys, and held back a little bit on the EB-5 program. But now that it's up and running again, we're delighted, and of course, delighted to work with you and your team. Good to see you again, Leon, and the rest of the guys. So, yeah, all systems go. So thanks very much for inviting me, and anything I can add to later on, it'll be great. But for now, I'm going to be a little bit of a participant because there's a lot more clever guys than I am on this program. So I'll be listening. But no, thank you, Stuart. And, our clients do ask from now and again, what's happened to EB-5, what's happened to the United States. Well, tonight we know it's alive and well and very, very strong going forward. So
Yep.
Thank you for that.
Perfect. And I mean, some of these new regulations really have some great benefits for South Africans. And then lastly, Garth Wellman from Callio Capital. We happen to share offices with Garth in Johannesburg, which is where our corporate offices are. But we've had a long association with Callio Capital. And Garth, as a family office, I mean, you've provided our investors some very valuable advice over the years. So really appreciate you coming online. And Garth and his team are there to assist us in terms of asking any questions in terms of tax consequences and how one sets one's affairs up in the US to be tax US friendly. So welcome, Garth.
Yeah, good evening. Like Chris, I'm going to sit back and do a lot more listening than talking. Currently dealing with the last stages of COVID, so my throat's not great anyway. But yeah, Stuart, it's great to see you again, Chris, Leon. I've worked with these guys for several years, and moving over to the US and changes in legislation and what impact that has on going over. It's all a very complex minefield. It's something that we've specialized in for close on 7 years. So we're here to help with the tax questions. We're here to help with how to fund this, how to create income on the other side. And certainly this change, which has now come into being this week, has created a situation for a lot of people having to move very quickly. So we're here to handle the financial immigration from South Africa and to create funding systems and planning around moving to the US, which is a very, very complex and very difficult tax regime. So we make it easy, and yeah, we're here to support the guys.
Thanks very much, Garth. Really appreciate that. And I look forward to traveling with Sheldon. We're leaving for the US tomorrow. But Leon, it's back into your hands. This is the long-awaited reauthorization of EB-5. It's been a sigh of relief for us, I think, collectively. At one stage, we wondered whether Senators Lally and Grassley were ever going to pull this off, but they did. And I think that certainly I like the reauthorization and I like the new regs. We're going to break it down into 3 components. So we start with, how these regs will impact current investors. We've got a lot of anxious investors that have been waiting for adjudications to resume and to be able to get across to the US and settle down. And then we will talk about how the regulations will impact prospective investors. And then we'll talk about some of the integrity measures, which is also a really nice portion of this new bill that's come into play. So certainly a lot of integrity measures, both for investors and a lot of scrutinization that will take place with regional centers that make these offerings. So I encourage those that are listening to pose questions. I will try and moderate them as we flip through the slides. But Leon, we're back in your capable hands.
Thank you, Stuart. So I think what we would do is take it from where we are at today, maybe first visit with those who have already had pending applications. Was probably one of the most frustrating times, I think, in our industry on this end too, especially with the hit of COVID, closing down borders, limiting certain countries, unfortunately also South Africa, from entering the United States, consulates being limited in operating, and then US CIS almost seem like they're coming to a standstill. And if that was not enough, we had the lapse in the EB-5. So a lot of frustration and a lot of long waits that nobody would have anticipated when we got underway towards the end of 2019. But as Stuart said, very anxious and very happy to see what Congress have come up with regards to the new legislation, because there's quite a few little golden nuggets in here that I think will greatly benefit some of those who've anxiously been waiting and whose cases may not have been approved. As I've mentioned with most of you who are our firm's clients, that we do expect immigration to adjudicate these pending 5 to 6 this year within the next 60 to 90 days, because during COVID and during the pendency of the lapse in legislation, they have indicated to us that they will continue to process these pending applications, but await adjudication until obviously we get reauthorization. So we are seeing things at the consulate happening. There's a few of our folks who are lined up and teed up for the final processes and going to the US consulate in Johannesburg, which is great news. But what I think is even better news is for those who are currently in the United States. On the pending, under the previous legislation, we had to wait for the I-526 to get approved before those who are in the United States could basically move forward with regard to their green card. This new legislation has included the pending applicants and those who are newly filing to file for what is called an adjustment of status in the United States. So if you are here on an L visa, E visa, tourist visa, student visa, whatever non-immigrant visa you are on, this legislation allows you to actually file for an adjustment of status, and I'll get to that in a second, while your I-526 is pending, and for those who will be filing, to file that concurrent with the I-526. This is great news because the adjustment of status then allows you to remain in the United States, you and your family, for as long as it takes them to adjudicate the I-526 and then ultimately the adjustment of status well. And the additional benefit that comes along with this adjustment of status is the fact that we will be filing travel and work cards along with the adjustment of status. Now that is huge because inherently out of a green card, the two main benefits that you get out of permanent residency is the ability to work wherever you want and to travel freely without needing to go to a consulate. This work and travel card that you get while your green card I-526 and adjustment of status is pending will allow you to do so. What's even better, just as a matter of 2 days ago, USCIS has also indicated they will be adding a premium processing that one can file while your adjustment of status is pending to also expedite your work and travel card. With huge backlogs on these work and travel cards, we had to historically had people wait here until those work cards and travel cards come in to allow them to leave the country or otherwise deem their application to have been abandoned. So this is extremely helpful for future plan making, because what has happened here historically with those who have had pending applications, it is a kind of a hurry up and wait. Is it going to happen next week? Is it going to happen next month? And everybody's plans are put on hold. In the meantime, life goes on. So this has been remarkably a sigh of relief, especially for those who have pending applications. So good news all around with regards to those who have had pending applications. The National Visa Center are moving forward with regards to sending those approved notices back to the consulate. We've reached out to Johannesburg. They've already communicated that they are going to be processing those approved cases in Johannesburg here within the next 60 to 90 days and start calling people in for interviews. And then also, more importantly, for those who have more tighter timelines, on a case-by-case basis, we can talk about how to process your application while waiting in the United States and or post-approval, come over here and change your status over here.
Yeah, Leon, I mean, this is just really exciting news all around. You know, it really gives investors that have been waiting for adjudication the ability to now move forward, relocate, do a status of adjustment, and not go through any additional frustrations in terms of when their case is going to be adjudicated. We at this stage don't really have an indication of processing timelines on I-526s. It's just to preempt. When do you think would be the first time that we're going to see a sort of pattern emerge for those that are not anxious, but are still pending and would like to wait here in South Africa for that approval to pop through?
I think once we get the first filings in, there are certain deadlines and timelines that Congress has also enacted and has formed part of this bill, when it's given some very short timelines on USCIS to actually adjudicate these cases, as opposed to just saying, well, it takes as long as it's going to take, kind of situation, which I think is also very helpful for those new prospective applicants who wants to file, knowing that there are some congressional and statutory timelines that are actually tied to these immigration benefits that's going to be filed. But otherwise, we've been told by USCIS that due to the fact that they have now had COVID and a lapse of reauthorization time to go through all of those pending applications that's been going on, that we're processing it. We are expecting here within the next 60 to 90 days to start seeing applications getting approved, and from there on, we'll be able to ascertain from when cases were filed on where their processing is with regard to those that have been backlogged and has been pending.
Great. And then Leon, just in terms of new regs and TEA, they're not current investors aren't subject to that. So their old regs are what they're going to be adjudicated on. So nothing to be concerned about on that side.
Yeah, absolutely. So not only do existing investors need to top up their investment in order to stay in the program, that's not at all the case. So you remain at the 500 that you filed at when you filed number one, and number two, there's new regulations that has been imposed upon the targeted employment areas would be grandfathered in for those who have filed under those previous TEAs. So there's also no concern with regards to the fact that your project may now all of a sudden fall outside of what the new definition of a TEA is.
Great. Leon, we now focus on the changes for future investors and those that are wanting to file. Obviously, I mean, we've been swamped with inquiries with guys eager to get moving. I think that the industry as a whole is going to explode with regional centers becoming very active again. So obviously people want to get their files in so that they can jump the line. Is it still restricted to 10,000 visas per annum?
Yeah, so there are 10,000, and they have also, in fact, in this new legislation, divvied those up. So I have been asked previously to say, hey, look, there's only 10,000. What happens, if that is oversubscribed? Well, what Congress does is just as far as the 10,000 is allocated, they will actually they would proportionate those visa allocations per country. And so you would see when you look at the availability of these EB-5 green cards that China is and has historically been ones that waits a little bit longer. We have never seen a backlog on South Africans. I don't think that they will ever get there, just because of the sheer population of people in China versus in South Africa. Those that have come close is other big countries like India with a large population, and maybe some other countries like Vietnam that has come close. But we've never been concerned with regards to running out of visas or green cards for South Africans necessarily. But what they've also done is with regards to the allocation of green cards that I think is going to be a game changer in moving forward, is they've actually allocated certain green cards for where you're going to be investing. So they have allocated 10% of the investment for high unemployment areas, 20% in rural areas, and 2% for projects that are involved in infrastructure. So as a new investor, when you start looking around, then I think that these will also be something to be taken into consideration.
Great. Leon, the 800 is now our token amount. I'm going to ask Garth. I mean, Garth, 800 is a chunky amount of money. But over the years, we've with your help managed to provide South Africans with some solutions in terms of how to fund it. It's always a topic. How do I take 800,000 out of my existing portfolio and put it in the hands of a project for, let's call it at a minimum 5 years? So what sort of financing mechanisms would a South African possibly have that they may want to consider?
Thanks, Stu. I mean, it's not just the financing mechanism. It's, you know, a lot of people might be considering this move, and, you know, I'm not talking to the existing investors, many which will be here and do know me, but just how to actually fund this and how to take capital out of the country. What is your allowance? Because, you know, $800,000 is exceeding already what your annual allowance is to take out of the country. But what's critical is often people, you know, look at this and go, oh, well, I have to sell all of my investments. I have to pay CGT from, I mean, I might have a share portfolio or an investment that's been around since 2000, and I've had huge amounts of growth. And then people get hit with a double whammy in that they've got to liquidate this portfolio to fund this project. And the project's a long project. So, you know, sorry, just give me a second. Thank you. Just sorting out the Jack Russells here that are having a go at each other. So, not to lose my train of thought, you've got this investment portfolio and it's had a lot of growth over time. So people now sit in a position where, you know, they've got to pay tax to liquidate this portfolio. So we created, and we're very prominent in operating in the Swiss Lombard lending space. And we do that through our SEC license. So we are a licensed American provider. And what this means is you can actually use a mechanism whereby you don't have to sell your portfolio. You can create collateral security against it. So you get the best of both worlds. I'm able to keep my portfolio intact. I don't have to pay that capital gains tax that would come with liquidating this to fund an investment. And we still sit in an extremely low interest rate environment. So we're able to, on extremely low interest rates, create capital from that and finance these projects. And then that also allows us to, and what we have done over the years is create investments with fixed interest rates. Because one of the most daunting things is getting settled, you know, getting credit over there. So we create that entire environment to fund, create credit, and also to create income going over. So that mechanism is known as Lombard lending. And we've been doing it probably longer than anybody else in South Africa. And it really does create a magnificent lending facility. It's not the only option. And, you know, we do bespoke solutions for any person who's going over. As a multi-family office, you know, there's very little that we haven't seen, and there's very little that we don't understand about, you know, creating this transition and creating the financial portfolios and dealing with the tax consequences. So yeah, in a nutshell, you know, we do create the solutions for people to fund this, and we create the tax optimization and immigration efficiencies.
Yeah, thanks very much, Garth. I mean, that's a great overview of the assistance that you help with our investors that are maybe considering EB-5 as an option. Leon, do you want to maybe just further focus on maybe the grandfathering aspects of the new regs? I think that's quite an important one. And then just in terms of the annual increments in terms of the investment criteria.
Yeah, so, you know, part of, I think we've talked about this before from a grandfathering point of view, those who have already filed would not need to increase their initial threshold. The TEAs remains the same under which application they filed. So nothing really for existing investors change other than getting the benefit of now filing also for an adjustment of status. There is also built into this legislation incremental increases in this so that we don't need to have what was going on in 2017, a stop and go and you know, file your application now because it's going to go up and, you know, create this rush in the market and uncertainty with regards to it. So they've come up with an incremental increase over the time that will kind of take care of an incremental increase that will hopefully keep up with inflation at this point. I don't know, but keep that incremental increase from a minimum threshold investment. Incremental increases that will move forward would not impact those who have filed. So you'll always stay at the 800,000 if you file today, despite the fact that even if your case lingers on and there's incremental increases by legislation that you won't necessarily, that you would not need to, add to your additional capital.
Great. I just we do see the questions coming in. We're going to be addressing those shortly as we near the end. But any other questions that you have, please just post them into the box, and we'll address them as we come to a close. Leon, the last one, capital redeployment. Let's say the project completes its lifespan and the capital may need to be deployed to another project to ensure that the investor gets immigration benefit. There's been some changes on that side as well.
So this didn't really impact South Africans. It was really kind of mostly the Chinese folks who were impacted by this, because your investment is tied for as long as your immigration timeline is there. And historically, it was usually a 5-year timeline for you to reach all of these milestones in order to get your capital back. So this is an investment, not a buying of a green card. So you invest your money and ultimately you can redeem that capital back. So historically, what has happened is at the time, because, as I mentioned earlier, Chinese folks are waiting a little bit longer than others, there's a time wherein the regional centers have finished the project, and now all of a sudden, and they are in target employment area, but now all of a sudden, they're done, but you still have some Chinese investors that are still in there and they cannot withdraw their capital from the project. Otherwise, their whole immigration process will fall flat. So under those circumstances, historically, they would needed to find another TEA that all meet the definitions and meet all the other regulatory criteria, which made it a little bit troublesome and a little bit difficult for redeployment. With the new legislation, it actually just talks and goes more to the issue with regards to having your funds remain at risk, irrespective of whether or not it is in another TEA project or not. So that's been at least a little bit helpful with regards to redeployment from funds is concerned, because that money needs to remain in there, like I said, until you as an investor getting the immigration benefit has reached the final milestone on removing the condition on your green cards.
Great. And then Leon, I mean, the other one, which for me is quite important, is the fact that in legislation now, they've actually written that, loans and gifts are permissible as a funding mechanism. Previously, it wasn't, and we, had to have some court cases to sort of facilitate that. But those are now very much imprinted in the regs. So there's a proper blueprint for that, which is really great news. So, loans and funding mechanisms from family members and third parties is now totally acceptable.
Yeah, that was usually a challenge. There was, like Stuart was mentioning, actually a court case that had to come through to decide and determine that loans are actually okay. So if you actually borrow money, that is okay. You can borrow money to invest into this program, where historically before that court case, borrowing money was not deemed to be something. You had to show that you have collateral more than the loan that you're borrowing it. It became very cumbersome from a source of funds point of view.
Leon, and then, I mean, finally, we're on to the final sort of section, and that's really about investor protection and integrity. This really was the whole long discussion that Senators Laley and, they put a lot of time and effort to making sure that these reforms were now in place. But do you want to maybe just unpack it? Because I think this is critical. I think
yes,
for the first time, we've now got this as legislation. And certainly it's going to really provide a lot of investor protection. And then also, TAs are now going to be issued by the Department of Homeland Security. So maybe just talk around these integrity measures, which I think is really great. It's going to really reform the program. And I'm very happy that these regs have come into play.
Yeah, absolutely. There has been, unfortunately, some projects that failed during the previous legislation, where there was some protection, but not a lot of protection under the regs, and most of those protections was under the Securities and Exchange Commission. But what this regulations has done is actually taken a little bit of a hands-on approach through the Department of Homeland Security, where there's actually have people come out and audit. There's actually some people who actually would audit this on a frequent basis, as much as 5 years. The regional centers would need to, and file certain paperwork every year and comply with the designation that they've been given. So quite a lot of measures has been put in place in order to protect you as a foreign investor who's not in the United States, may not be in the United States, to protect you from an investment and or a project that may fail, in order to help you move to a different project, as a for instance. So this is very good news. How is that funded? Because USCIS is a fee-driven agency. It's not necessarily covered by the government. So the regional centers where you invest actually would have to pay a fee as part of them being designated as a regional center to USCIS to actually have this happen. This is not uncommon necessarily, maybe just on a bigger scale, but it's not uncommon with regards to immigration. There's certain visa categories too, where USCIS will actually send agents out to an employer to actually see whether or not the guy is working there, to see what the circumstances are, under which the guy is working, and so on and so forth. So these integrity measures is kind of being borrowed from some other visa categories and implemented in here that I think is extremely helpful. Now, the only thing that I think here that may ultimately cause, I think, some debate is the fact that USCIS now, or the Department of Homeland Security, is now specifically tasked to designate what a TEA is. A TEA was previously designated by an economist and someone who would actually, and the local and state legislators to determine what that TEA is. And there was quite an elaborate explanation made from these agencies with regards to the amount of people that are there, the unemployment, and so on and so forth. So in order to substantiate that you're a TEA. Now, I think the main reason why Department of Homeland Security has taken that into their hands is because you had some fancy New York lawyers that will draw fancy lines into Brooklyn and then include downtown Manhattan as a TEA in order to get projects done over there. So I think that this TEA is probably going to be a little bit more on a controversial side from the immigration attorney side in order to get designations done. But with because some would want to have their projects obviously funded, and some, may argue that the TEA designated by the Department of Homeland Security may not necessarily meet their definition. But we'll see as we move forward. At least the projects that we are working on with Stuart and them all meet the current definition on the new TEA. So happy to move forward on those.
Great, Leon. I think let's maybe start answering some of the questions. The first one is from Vikesh. I invested in 2019. I'd need to know whether the change in legislation, I can move to the US in the next few months and apply for AOS and start up a business in the US.
So I think for anybody who wants to move to the United States, there needs to be careful with regards to entering the United States and just filing an adjustment of status. There is deemed to have been, or could be deemed to have maybe some issues on entering the country with a non-immigrant.
We've lost you there, Leon.
Can you hear me?
But I'm going to answer that question. I think that where we have investors that are wanting to take advantage of this, then obviously we would need to have consultations directly with yourself and your immigration attorney. I think each case is needs to be spoken about on its own personal merits.
I agree.
Leon, the next question relates to backlogs. What has been done to clear the backlogs?
So as I mentioned earlier, I know, and the industry has been in communication with USCIS. They have been processing these applications that's been pending. We just don't know yet as far as where your application that was filed in 2019 falls in with the adjudication that will now happen subsequent to the reauthorization that was signed by the president just a couple of weeks ago. We will anticipate to know what those timelines are going to be once we start getting the first approval notices, which we expect to happen within the first 60 or 90 days. And then we will communicate with the regional centers that we work with and saying, hey, look, We just now got a whole batch of approvals of cases that was filed in the second quarter of 2019. So if your guys filed in the third quarter or fourth quarter of 2019, you can expect probably wait a couple of more months. But we'll continue to monitor those timelines as we start getting approvals that will come in.
Great, Leon. Another one, somebody who wants to take advantage of doing a status of adjustment, waiting for approval. Would his kids benefit from reduction in terms of school fees, or would they still be regarded as international students?
I think they will still be regarded as international students, but that's a good question to ask the university. If a 485, which is just the number of the form, is filed, I've seen some universities that do certain things and take them off the program, but that's a question to ask the university. So I guess my answer to that is ask the university, what happens if I file my 485 application and I can show you a receipt? Does that take me off of the international student list?
Okay. Leon, a lot of people just really wanting clarity again on entering the United States, doing a status of adjustment and waiting out for approval. My suggestion is that we'll reach out to these people directly. I think the merits of them are each on case by case. I don't think we want to just provide a blanket sort of answer in terms of that. A lot of it revolves around whether you're actually in the US on another visa category, or if you intend coming into the US on a certain visa category, and then doing a status of adjustment. So I think that with respect, we've got all of these questions noted, but we're going to circle back to you individually and give you more direct answers. Here's a good one from an investor. With the funds being at risk, what are the percentage odds of the investor losing investment or part of the investment?
That's a good question. You should ask the guys where you invested with. I'm the immigration guy.
No. So I think the terminology is your investment is at risk. I think, you know, from our side, obviously, in terms of the project selection that we're involved ourselves in, and so does Chris, we've never ever had a capital failure. So I think it's very critical that one understands the asset class that you're going into, understands who the managing members of that investment are, what the exit strategy is. But with a good project, your full capital should come back to you. I mean, that's really why these projects were designed. They weren't designed for you to lose money. So it has happened, but I think with a lot of these new integrity measures, some of the guys that shouldn't be in business won't be in business. But certainly, we've never been involved in any projects that have had a capital failure. Leon, just another question. Timeline to citizenship, just briefly.
Sure, no problem. As soon as you get your green card, the moment you get your first conditional green card, there's a 5-year timeline that's going to start ticking towards permanent resident, towards citizenship. It's only at that 5-year mark that we will look back to see if you're eligible. What could make you not eligible if we haven't spent more accumulatively 2.5 years during that time frame in the United States. So there's a few other qualifying measures, but the 5-year is the soonest that we can look, irrespective of your conditions on your green card has been removed or not.
Great. And then we're going to have two last questions. Nigel asks, when do I need to pay the 800?
So as part of the application, we would need to show that you have invested or are in the process of investing. So the answer then is you need to make your investment before I file.
Yeah. Nigel, I will reach out to you to talk around timing and maybe a project. And then the last one, Leon, is just about a kid. Any changes to the requirements of kids being over 21 and being included in the application?
Unfortunately not. No, kids over 21 today would not be part of the application. If you file the application today and your kid happened to be 20 years and 10 months, his age will be locked within immigration and will be protected under this new legislation, but also more importantly under the Child Status Protection Act that will freeze his age in time until such time that he pops out on the other side in order to get a green card.
Great. And then I've got a question. I'm 61 years old. That's young. Do I do I still qualify to be eligible to get into the US?
No age requirement, no academic requirement, no medical requirement. The only requirement is that you have invested your money into an approved project, number one. Number two, that you are a person of good moral character. And that's basically it.
Yeah. Great. Leon, we've still got about 40 odd questions, but I think we've dealt with most of the pertinent ones. I think the message that we really wanted to get across is that we collectively are very excited about this new long-term reauthorization. It allows for a certain amount of flexibility, which we didn't previously have. And I think, as I've said continuously, I think some of these new regs related to investor protection and integrity are really going to put this EB-5 investment visa program back to where it was intended to be. So
I just have one more comment to make, Stuart, before you sign off. I think that COVID and this lapse in reauthorization has actually benefited this program in the reauthorization thereof, because Congress has actually, as part of this new legislation, saw the frustration that happened when the lapse happened. So this new legislation would not have a lapse in reauthorization have any effect on those who are currently pending. It's in fact designated in such a way that USCIS is instructed to continue to process those and adjudicate those processes, which is great, number one. And number two, the reauthorization will then happen irrespective of where we are at. And at this point in time, we're good to go for quite a few more years. So I think that the frustration that happened between COVID and between the lapse of reauthorization is also covered on this bill with regards to moving forward, and we'll have some greater certainty with regards to timelines this time around than what we have historically seen.
Chris, do you have any sort of closing comments? I mean, you're the alternative residency citizenship guru here in South Africa. So, I mean, this is welcome news, isn't it? You're on mute.
One of the lasting words in use during COVID, you're on mute. Eh? We've had a few of those before. So yeah, I mean, it just sort of, closes the circle of our bouquet of offerings. People say, well, you guys are strong in Europe, you're strong in the islands and Pacific Ocean and stuff, in the Indian Ocean, I should say. But for the United States, it's been glaringly, sort of missing in the last while, whilst we went through this sort of impasse in the legislation. Now that that's all cleared up, it's really good for us. So we know where to send the clients that are inquiring about going that side. We'll send them straight to your office, Stuart. I mean, you guys have been great for us and worked well with us. And together with the team that you've assembled, we're very confident that whoever wants to get to the States via the new legislation will eventually get to the States. There's some hiccups, of course. There's been hiccups in many of the programs that we're working with, but ultimately, the people do get there. I was delighted to a mate of mine phoned me this afternoon to say that his wife's Portuguese passport has just arrived. Now we've got a few Portuguese citizenships that have gone through, but that's the first passport that's arrived. So it's always nice when those things happen, and to see the programs achieving the end result that people want them to achieve. And with this one back on track, it's great. We're able to offer our clients a solution for those that want their kids to go and study in the United States, and eventually maybe to immigrate and go live in the United States. So we're very excited by it. Thank you.
Great. And Garth, some closing comments from you. I'll be traveling with Sheldon to the US tomorrow, so I'll be showing him around. But
yeah, just closing comments. I mean, for those who don't know who Sheldon is or who you're talking about, he is ex-head of Nedbank Wealth, joined Calio to spearhead the US office. He'll be flying over with Stuart. So we have that presence in the USA to facilitate people landing and going over. And yeah, just to reiterate on what Chris was saying there, we've got a lot of clients who have gone through this process many years ago that are living and working, and children in varsity in college in the USA. It's a great program, and the quality of the programs that American Dream has put forward for the for the EB-5, I mean, just looking at that risk on the investment, I think it's very important to understand it's a quality operation, quality partners, and it really, really is a good option. So yeah, from my side, if there's anyone who wants to get in touch with us around the US and the finance side of things, and how and what the taxes are involved and how to leave South Africa, impacted by going into the US and the number of days making you tax resident, reach out to Stuart, and yeah, we'll also be in touch with you on a personal level.
Great, thanks very much, Garth, and thanks to all my panelists. That's been a very, very informative session. It was thanks to Leon for going through all of that. But we're all going to be in the US next week, so we're attending some conferences. So it's going to be interesting to see how excited everybody is about this reauthorization. But thanks, everybody. We know that we've got a lot of unanswered questions, but we will be answering those individually back to you. And then we'll be giving you some follow-up information post the conferences that we're heading out to attend to. So thanks very much, really appreciate it. And thank you for registering to join us this evening.
Thank you.
Yeah.
Thank you.
Thanks,
Take care,
guys.
everybody.
Take care.
Cheers. Bye-bye.
Bye.
Chris.
Bye.